Can a 1798 law be used to mass arrest and deport illegal aliens as invaders? Can a federal judge tell the president to return an airplane mid-flight to the USA for violating the 1798 law? Can the president define the class of enemy aliens who get removed from America without a court hearing to ensure the person is within the defined class? The law at issue is an act that implements the internationally recognized right of every nation to protect itself during times of war from individuals whose primary allegiance lies with a hostile foreign power. That law is what we will look at today, given the attention brought to the law by President Trump in the 2024 election and the discussion about the illegal immigration problems in the country. In 2025, after President Trump assumed office, he then issued an executive order, began the removal of certain aliens to Venezuela, and this led to a showdown with the judiciary over returning airplanes and the propriety of the act as used by the executive. But first, hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a look at the fascinating legal questions raised by the Alien Enemies Act of 1789, the questions about invocation of it by a president to address the illegal immigration problem, and the resulting showdown with the judiciary. This has been all over the press, of course, in early 2025, and you, the curious lawyer, need to be able to answer questions at cocktail parties or when non-lawyer friends ask. No spin here, no politics, just the straight analysis of the law, so you can decide for yourself the likely outcome. We ultimately ask, how have courts treated this old law? How much deference is given the president? And what is the likely outcome after the president declares an invasion and identifies a particular gang as falling within the act? So sit back, and after this hour, you will know all the key points about the law, the case law, and the role and limits of the judiciary in looking at these issues. Let's start with our agenda today of what we are covering. We are looking at the statute and the limited case law that has interpreted it historically, and we will look at the current 2025 litigation. We will go into the statute more, but I want to give it to you out of the gate so you can see the key language that drives the issues we will address. As you see, there are two prongs, the war prong and the invasion prong, and each of those litmus tests allows the president to order all people over the age of 14 who come from the foreign nation we are at war with or invaded by to be arrested, detained, and then removed. The two prongs are very important because, as we will see in the limited historical case law, it revolves solely around the war prong. We will therefore look at the case law to understand the scope of judicial review of this law as it relates to the war prong to divine meaning on the invasion prong. We will look at how expansive it is, or how limited it is, which requires us to consider as courts have the political question issues, namely that courts generally stay out of political questions. Ultimately, we will be looking at the Supreme Court case law and the way the war prong has been interpreted. We will look at the arguments for and against the use of the invasion prong, given our 21st century facts relating to illegal immigration problems in America. And also out of the gate, it facially does not just apply to mass illegal immigration, so it is not a tool to use to address mass illegal migration in itself. So the question we must stay focused on as we walk through this thicket of law is whether a foreign nation or government is conducting an invasion of predatory incursion. That is, there is a nation-state-based nexus facially to the statute. And if it is used as it has been, we will look at the battle that has erupted over the use of the law and whether it is amenable to a class action, or whether the cases need to be brought as individual habeas cases. And regardless of legal vehicle, we will look at what level PF process is required before one is deemed a member of HTE group and removed. As an aside, one point out of the gate, This law was not the law used in World War II to intern Japanese Americans. That was done by a different presidential executive order, which led to the famed Koreamatsu case upholding the detentions. This law today we are looking at today in this program instead deals only with non-United States citizens who are from foreign lands. We will also assess parts of the oral arguments in the federal courts over the case to hear the discussion between the lawyers for the executive and the judges for the federal judiciary in what can be fairly described as a battle between the judiciary and the executive over the law, and who gets to call the legal questions on the implementation of the law. So now back to our statute again. There are 4 parts to the statute sections 21 through 24, and we will look at all of them. The main one, of course, is section 21. Here again we see the war prong and the invasion prong, which allow the president, if either is triggered, to apprehend, detain, and ultimately remove natives or citizens of the hostile nation at issue. It says, quote, "Whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President makes public proclamation of the event, all natives, citizens, denizens, or subjects of the hostile nation or government, being males of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies." End quote. When the statute was originally passed, it specifically referred only to males over the age of 14, and that was amended in 1918 to cover all people over the age of 14. The question we are asking is, what is the scope of the invasion prong? Obviously, when we are not at formal war with a country as declared by Congress, the question is, what does the invasion language mean? Does it mean literally the way we understand the word today, that a large number of people may come in and in some non-literal sense invade our country? Or does it have a specific meaning as understood at the time that relates to war-related efforts by a foreign country? These are the questions we will look at and try to answer as we walk through the statute and the case law. As you can see, if it is triggered, the President is allowed by proclamation to establish the rules and manner that define the nature of the restraint of enemy aliens and how they can be removed. Let's now look at the 2025 order issued under this Act. Let us start with the President's 025 Executive Order and Proclamation under the Act. Here's the key language. I won't read it all for you as you can read it here, but I did bold the relevant fact findings of the President that led to the declaration and proclamation of an invasion. The important question we address is whether that set of findings is subject to judicial scrutiny and judicial rejection as a trigger for the conclusion of an invasion. Now let's look at Section 22 of the law itself. What does this mean? In essence, Section 22 is a limiting principle on Section 21. Section 21 defines the broad range of powers the President has to deal with enemy aliens. But Section 22 makes clear that if the enemy alien is not someone who's actually engaged in public safety crimes or open hostility against the government, that person is given some amount of time to settle their affairs in essence, either based on existing treaties between the United States and the country at issue, or if there is no such treaty, then a reasonable time is declared by the President. In other words, if the enemy alien is not a threat, they are entitled to some amount of time to get their affairs in order before they are actually removed from the country. Now let's take a look at Section 23, which is titled Jurisdiction of United States Courts and Judges. This is an important section because one of the issues that we will see in the case law is the scope of judicial review of a presidential invocation of a Section 21 finding. Now I highlighted important language for you here, because as you can see, Section 23 does, by its title itself, vest jurisdiction in courts and judges to assess some aspects of a Section 21 finding. And as you can see in the bolded language, it provides that the judges, upon a full examination and hearing of a complaint made by someone that they are improperly being removed, is then able to assess the question and order the imprisonment or removal. The question we will look at is what is the scope of that examination and hearing that the United States judiciary may make when a situation arises? In other words, with a Section 21 declaration, are the courts allowed to assess whether it really is or proper a war or invasion? Or must they simply accept that the judicial inquiry is limited to assessing whether there actually has been a declaration of war or invasion, and whether the person is a citizen of a foreign nation or not? Those are more narrow jurisdictional questions, of course. But as you can immediately see, it will become very important in understanding the role of the judiciary in assessing a presidential declaration of an invasion or predatory incursion under the second prong. Would courts be allowed to second-guess the president's declaration of an invasion or a predatory incursion? Would courts get to define what is an invasion within the statute? That is, if the president says that an invasion or predatory incursion occurred, would the courts be allowed to redefine the president's understanding of those words and therefore conclude that the president is wrong in that assessment? These are the fascinating and complicated questions that drive ultimately the analysis. The questions, as you can see, that are more complicated than the question of whether a war exists, which is in many respects a light switch event. If Congress declares war, there is a war, and there's nothing for a court to look at. But since the Constitution does not demand Congress be involved in declaring an invasion or incursion, we are left with the more thorny question of the role of the courts versus the president in defining and examining this question. So let us now do a quick recap so that the issues can be framed as we start looking at the case law. Remember, we have two prongs. If a war is declared between the United States and another country is one prong. Or as our second prong, if there is an invasion or predatory incursion perpetrated, attempted, or threatened by a foreign nation or government against the United States. If either of those two prongs are satisfied, then the executive can make the public statement and proclamation of that, and order the arrest and detention and removal of those over the age of 14 who are not U.S. citizens and are instead citizens of the foreign nation. The executive gets to issue the rules on the conduct of this process. But remember, if the person arrested is not an actual warrior fighting against us or a public threat, then they do have the right to some amount of reasonable time to get their affairs in order before removed. And courts have jurisdiction to look at cases under Section 23. The issues, therefore, that we are circling around relate to what is the scope of the jurisdiction of the courts. What is the realm of political questions that belong to the executive and not the judiciary in terms of deciding whether a predicate war or invasion actually exists? Who decides that question? How much judicial review of that question is available? Or are courts limited only to looking at the narrow jurisdictional questions of whether people are citizens and over the age of 14 of a foreign country, and whether they are part of the defined group for removal upon a declaration of war or invasion? Or do courts get to look behind the declaration of war or invasion and assess whether there is in fact a war or invasion underway? Ultimately, do our courts have some sort of supervisory role coming from Section 23 or more broadly due process to address the legitimacy of an executive determination of an invasion? And if so, what would that even look like? And how much is reasonable time to allow people to get their affairs in order? Some of these questions we have answers from courts on, but some of them we do not. The reason for this is that the only case law we have relates to the war prong under this act, as there has never been a case litigated over the scope of a presidential proclamation of an invasion or predatory incursion. As I mentioned, we have 3 instances where a presidential Section 21 proclamation has issued and which has resulted in some litigation in the courts. So now let's take a look at our 3 examples from history and the resulting case law to help us answer these thorny questions. The first of the 3 historical examples where Section 21 was invoked was in the War of 1812, and this was when President Madison issued a proclamation with respect to expected British enemies within the United States. His proclamation required British citizens to report and register information about themselves with the government. Now, of course, the War of 1812 under the Constitution, which precipitated the President's invocation of Section 21. In turn, this proclamation led to some litigation, and the first reported case involving the Enemy Alien Act was in 1817, and as the case of Lockington versus Smith, you can see the citation here. Before we get to the basic facts and what happened, one overarching principle is important. The case involved a prolonged detention without deportation or removal back to England. The overarching principle that the court held is that, as you can see here, quote, the power of the president under the first section of the law to establish by his proclamation or other public acts rules and regulations for apprehending, restraining, securing, and removing alien enemies under the circumstances stated in that section appears to me to be as unlimited as the legislature could make it. It seems perfectly clear that the power to remove was vested in the president because, under certain circumstances, he might deem that measure most effectual to guard the public safety, but he might also cause the alien to be restrained or confined, if in his opinion the public good should forbid his removal. End quote. So, as a large framing principle before we get into the case, what we can see is that the first court to look at this law concluded that this was a massive vest of discretion in the president to make these determinations as to whether people should be detained or removed or both. Let's now take a look at the facts of the case and get into it deeper. The basic facts are as follows. The plaintiff in this case was a British citizen, and after the proclamation of war and the registration requirement issued by the president under Section 21, he registered with the government. However, the rules issued by the president require people to stay a certain distance away from the shore and tidewaters. This plaintiff failed to do it, was arrested, and was imprisoned. He then sought release under Section 23 in a federal court action, arguing that he was detained too long and should be removed to England. As you saw already in the prior slide, the first thing the court concluded is that the president has vast discretion to direct the conduct of how people are detained and or removed. But the scope of the executive power goes further, as this case held. It is a provision for the public safety, which may require that the alien should not be removed, but kept in the country under proper restraints. It is never to be forgotten that the main object of the law is to provide for the safety of the country from enemies who are suffered to remain within it. In order to effect this safety, it might be necessary to act on sudden emergencies. The president, being best acquainted with the danger to be apprehended, is best able to judge of the emergency, which might render such measures necessary. Accordingly, we find that the powers vested in him are expressed in the most comprehensive terms. This, of course, is a massive statement of deep deference from the courts to the executive in terms of being the person to apprehend the dangers and act accordingly with limited judicial review. And with respect to the plaintiff's argument that was put to the federal court that the courts must look to the regulations created by the president and enforce them and allow his removal, the judge in this case held that, quote, such a construction would, in my opinion, be at variance with the spirit as well as with the letter of the law, the great object of which was to provide for the public safety by imposing such restraints upon alien enemies as the Chief Executive Magistrate of the United States might think necessary, and of which his particular situation enabled him best to judge. End quote. And here is the powerful line on deference as articulated by the Lockington Court. The Alien Enemies Act appears to me to be as unlimited as the legislature could make it. This is grant of deep deference to the president on his discretion to use the act and arguably a resulting limit on a court's ability to check that act of discretion. Now, it turns out the act would lay dormant for nearly another century until World War I, which brings us to the second utilization of the act and subsequent cases discussing it. In 1917, Congress declared war on Germany and other European powers and joined World War I period at the time President Woodrow Wilson issued a proclamation under Section 21. Under his proclamation, he declared that any alien enemies in the country who may be believed to be supporting the German war effort would be subject to summary arrests, confinement in prison, or in a military camp. There was also a registration requirement, and the National Archives indicate that around 480,000 Germans in the United States registered with the government. In total, around 6,000 were actually detained. And if you want to read more about that, you can at the National Archives article I have linked here for you. President Wilson's proclamation also prohibited enemy aliens from possessing firearms or ammunition, using wireless devices, and using aircrafts, period. This was in addition to the registration requirement, of course. Now, as a quick aside, At this time also the Enemy Alien Act was amended to remove the word males, so that it would apply to all genders. It appears the Founding Fathers were only concerned with male enemies, but by World War I, the President was concerned about both genders potentially being involved in espionage or spying activities. So let's now take a look at one of the early cases to come out of President Wilson's Section 21 proclamation, and this is Lacey versus United States. This case involved some plaintiffs who were indicted for aiding and abetting the escape of some Germans who had been detained under Section 21 period. Now the parties who had been indicted argued that the Alien Enemy Act of 1798 was unconstitutional and deprived people of liberty without due process of law. If they could show that the act as applied to the detained Germans was unconstitutional, then they could not be indicted, obviously, for aiding and abetting a violation of that law. What did the court hold as to the constitutionality of the act? It found the law constitutional. Here is what the Ninth Circuit said. Quote, starting at the second sentence, while as to property rights and life and liberty, all aliens domiciled in the United States, or temporarily therein, are accorded the equal protection of the law and due process of law, such is not the case as to alien enemies. Alien enemies have no rights and no privileges unless by special favor during time of war. Such was the common law. Alien enemies have no rights, no privileges unless by the king's special favor during time of war. And you see there a citation to Blackstone and Old Common Law. Continuing quote. There is nothing in the Constitution or laws of the United States which in any way has changed the common law rule or restricted the power of Congress to enact the alien enemy law. Power to enact such a law may at times be essential to the preservation of the government, and the right of all nations to exercise it is recognized in international law. End quote. So that is a clear holding that the law itself was completely constitutional and was the codification of ancient common law that concluded during the time of war, enemy aliens have no rights or privileges unless granted by special favor. If we look at this case of Graybar, this was the one of the first decisions in the World War I era addressing the act. Here, a Croatian had been detained and argued that he had intended to become a naturalized citizen when he entered in 1903, but never was able to do it, and so he should not be considered an alien enemy. But the court refused to look at his loyalty to the United States and simply concluded that since he was a citizen of an enemy state, the inquiry ended. You can see the quote here that says that the executive's determination that he is an enemy alien is final and conclusive and not subject to the review of the courts. In other words, the courts only look at jurisdictional facts and not more. And in another case called Reese from New York, here the court looked at who has the burden. This case explained that as between who has the burden, specifically is it on the alien enemy to prove he is not an alien enemy, or is it on the government to prove that he is in fact one? This court concluded that, given the nature of the statute giving expansive powers in a time of war, it must be that the presumption is that the president acts lawfully, and people who are detained are lawfully detained, such that the burden, therefore, is on the person detained to show that somehow they are not a citizen of the state they are claimed to be a citizen of, or that there is not a war, for example. This case was important because the person detained claimed to have been born in Mexico and so was not a German enemy alien. But the court looked at all the facts and ultimately concluded that it was unable to affirmatively find that he was not Mexican. That is, he may have been Mexican, but also he may have been a citizen of Germany, even though the court could not affirmatively conclude he was indeed a citizen of Germany. But because of where the burdens existed, it was the petitioner's burden to show that he was indeed not a citizen of Germany. And this court ultimately concluded that he couldn't rebut the government's conclusion that he was, even if the court did not know for sure one way or the other. But one key point that is important: the alien was at least able in court to try to make a showing that he was not within the class at issue. This now brings us to the third major episode in American history where the Section 21 proclamation was issued, and this is during World War II by President Roosevelt. Here, in a series of 3 proclamations, President Roosevelt deemed the Japanese, German, and Italians, who were non-citizens in the United States, to be alien enemies, and therefore required registration with the government, and they were subjected to a series of regulations that restricted their activities, as in the similar prior proclamations we have looked at. The proclamation also specifically permitted summary apprehension and internment for the duration of the war. Any such enemy aliens if they were perceived as being dangerous to the peace or security of the United States. This is the World War II case that tested the law. Here are the basic facts of this case. The petitioner, a German, was arrested in 1941 and placed in an internment camp in 1942. He was then ordered to be deported to Germany in 1946. However, he argued that he could not be returned to Germany because the war had ended in 1945, and so his continued detention was unconstitutional and he had to be released. His claim was rejected in a 5-4 decision by the Supreme Court. There are 4 key points the majority make. First, the language employed by the Fifth Congress could hardly be made clearer or be rendered doubtful. The act concerning alien enemies, which confers on the president very great discretionary powers respecting their persons, appears to me to be as unlimited as the legislature could make it. Second, quote, the very nature of the president's power to order the removal of all enemy aliens rejects the notion that courts may pass judgment upon the exercise of his discretion, end quote. Third, war does not cease with a ceasefire order, and power to be exercised by the president, such as that conferred by the Act of 1798, is a process which begins when war is declared, but is not exhausted when the shooting stops. Its termination is a political act. Fourth, whether and when it would be open to this court to find that a war, though merely formally kept alive, had in fact ended, is a question too fraught with gravity even to be adequately formulated when not compelled. These are matters of political judgment for which judges have neither technical competence nor official responsibility. These are very powerful points. What is important here is the court noted that war could be terminated by treaty or legislation from Congress or even a presidential proclamation. And specifically, however it is to be terminated, that is a political act too fraught for a court to wade into. That is powerful language. And we should pause and double-click on that, because that casts a potentially long shadow over prong 2's invasion question. The same analysis could apply there, whereby a court concludes that the beginning and termination of a, quote, end quote, invasion is a political act for the other branches of government to adjudicate, not the courts. The argument that this case could support the power to arrest and detain certain people without judicial scrutiny would therefore rely on this language and structure. Now, the court also addressed the voiced concern from both the dissenters and the petitioning party that war powers could be abused by the president, and so therefore, judges needed to be more involved in supervising this exercise of discretion under this act in order to make sure the executive does not overreach. The court specifically rejected that argument and cited to an old case from the 18th century with a quote that's worth us reading here. All systems of government suppose they are to be administered by men of common sense and common honesty. In our country, as all ultimately depends on the voice of the people, they have it in their power, and it is to be presumed they generally will choose men of this description. But if they will not, the case, to be sure, is without remedy. If they choose fools, they will have foolish laws. If they choose knaves, they will have knavish ones. But this can never be the case until they are generally fools or knaves themselves, which, thank God, is not likely ever to become the character of the American people." End quote. So then, for a bottom line holding, the petitioner lost, because even though the war had ended in terms of bullets being fired, the president still decided in 1946 that the Section 21 structure should stay in place. And until he decided otherwise or Congress formally declared the end of war, the courts had no business being involved. This is both structural deference on Section 21 decisions about the triggering event, here war, and also the limit or a court's role on the triggering event determination. Now, this case had 4 dissenters, so it was by no means a slam dunk. Let's look now at the dissenters and what they said. The dissenters were Justices Black, Murphy, Douglas, and Rutledge. They said, "I think the idea that we are still at war with Germany in the sense contemplated by the statute controlling here is a pure fiction. German aliens could not now, if they would, aid the German government in war hostilities against the United States. The 1798 Act did not grant its extraordinary and dangerous powers to be used during the period of fictional wars." End quote. What is important in this conclusion of the four dissenting justices is that the courts do get to pull back the curtain and look behind through a quote war end quote determination. They do not need to be bound by the other branches of government and their adjudications of that question. Indeed, here, as you can see, the dissenters said that since all hostilities ended in 1945, they believed that it was a fiction to even say that a war still existed, and so therefore they concluded that the court should be able to actually say that the war was over, and therefore the Section 21 power had ended. And so as a result, the complaining party could no longer be removed or detained. The dissent also said this, quote, "The notion that the discretion of any officer of government can override due process is foreign to our system. It is well established that the war power does not remove constitutional limitations safeguarding essential liberties." End quote. You can see the obvious long shadow cast by that argument that would cut against the ability for the executive to make a unilateral invasion determination without judicial review period. But at the same time, this was a set of dissenting justices and not the majority. In another case involving German enemy aliens in World War II, we again have a chance to look at the scope of a federal court's ability to peer into the question of whether a war exists or has ended. This case comes up in a slightly different context, but is also an important period, and of course it was a U.S. Supreme Court case. Here are the basic facts. Plaintiffs alleged that prior to May 8, 1945, they were in the service of German armed forces in China. Post-surrender by Germany, they continued to fight. They were convicted of violating laws of war by engaging in, permitting, or ordering continued military activity against the United States after surrender of Germany and before surrender of Japan. Their hostile operations consisted principally of collecting and furnishing intelligence concerning American forces and their movements to the Japanese armed forces. After the Japanese surrender, they were caught and convicted and sent to prison. They argued a variety of constitutional claims outside the context of our Enemy Alien Act. But the court did address the Enemy Alien Act in part in resolving the case. Here is what the Supreme Court said that is important today, of course. The resident enemy alien is constitutionally subject to summary arrest, internment, and deportation whenever a declared war exists. Courts will entertain his plea for freedom from executive custody only to ascertain the existence of a state of war and whether he is an alien enemy and so subject to the Alien Enemy Act. Once these jurisdictional elements have been determined, courts will not inquire into any other issue as to his internment. End quote. That is a further important principle that courts look only to the jurisdictional facts. Does a state of war exist by looking to what the Congress or President has said? And is the person at issue an enemy alien? A narrow view of those questions delimits substantially the scope of federal court inquiry. Here's what the Supreme Court also said as a key framing policy principle to delimit litigation and court enmeshment. Executive power over enemy aliens, undelayed and unhampered by litigation, has been deemed, throughout our history, essential to wartime security. That's at page 774, and reflects judicial concern over limiting federal court involvement on war security issues that the executive deems necessary. It also ruled that, quote, "the essential pattern for seasonable executive constraint of enemy aliens, not on the basis of individual prepossessions for their native land, but on the basis of political and legal relations to the enemy government, was laid down in the very earliest days of the Republic and has endured to this day. It was established by the Alien Enemy Act of 1798. End quote. Of course, the complexity we confront is what happens when it is not a congressionally declared war, and instead we are under a presidential declaration of invasion. This question, then, is one where only one branch of government has acted as opposed to war, where two branches have agreed. And that pits the executive and judiciary in conflict in the 21st century given the invasion determination of the executive. Here we have another important case that deals with the distinction between Section 23 jurisdiction of courts over the President's proclamation or an actual court case. And what this court, the Second Circuit, said in 1946 is that the only question that courts can look at is when an action is actually filed by someone contesting what has happened to them. Then the court may exercise that Section 23 jurisdiction to look at the issue of whether the person is an enemy. Other than that, the executive action is off limits. This is important in our current Venezuelan incursion dispute because the plaintiff's argument in the case is that they are not in the gang and so have been mislabeled, and a court has to be able to address that much. Let's now turn to the cases that have consumed the American legal system in 2025 over this issue. Let's take these principles now and turn to the first question that we have been pondering, and that is the scope of judicial review if there is a presidential Section 21 proclamation with respect to the second prong of Section 21, the invasion prong. Now, of course, the war prong is the easiest case, because Congress is required under the Constitution to declare a war if the country is to formally be in a war period, but there is no similar provision for an invasion or a predatory incursion as the language is written in Section 21. So we cannot look to a light switch event of whether Congress did something or did not do something to know whether the Section 21 power has been exercised properly. The first question we have to consider is whether the invasion or predatory incursion language itself requires the context of an actual declared war, or does it apply to non-declared war situations that are perhaps preparatory to war, but not yet at the point of a formal federal congressional declaration of war. This raises the question of what exactly does the language even mean? And of course, the language also requires that an invasion or predatory incursion be done by a foreign nation or government, as opposed to individuals or citizens of that foreign country. So the focus is on foreign governmental invasions or predatory incursions into our country. This, by definition, narrows any broad use of Section 21 to combat what is fundamentally an immigration issue. The question then this raises is, could foreign gangs be deemed a foreign nation, and if so, how? Or perhaps could a foreign government that decides to empty its prisons of a particular group of people and actively encourage or ask them to go into America, would that be Section 21 triggering language? And if the president made a finding on his record that these things happened by a foreign government, how limited would court inquiry be into that finding? And the important question then becomes, if such findings and proclamations are made by the executive of those types of events, what is the scope of review of a federal court as to those questions? Would it be limited strictly to a jurisdictional thin inquiry, as we saw in the cases throughout history? Or would the court actually look deeper, pull back the curtains, as the dissenters in the seminal Supreme Court case argued, to really figure out if there is an invasion by a foreign government or a predatory incursion by a foreign government afoot? Remember those cases that we looked at that go from the 1800s to the early 1900s to post-World War II talk constantly about the extreme breadth of deference given to the executive. And so we have to wonder today, would the dissenters view control today, a federal court inquiry, in light of the fact that there is an invasion? In other words, there's no external source in the legislative branch that we can go to conclude that they have voted on the existence of such an event. Of course, even that may not be true, because the Congress could vote and make a finding or resolution of some kind that it believes is an invasion or predatory incursion has occurred by a foreign government in a particular specific circumstance involving certain groups of illegal aliens entering the United States. In that case, we would have to ask then if the courts could second-guess that. These are all the thorny questions that we are now confronting. So let's double-click on some of this and go deeper. Let's unpackage then the arguments for and against a presidential use of this law to mass arrest or deport aliens in more detail. And let's first explore the working definition of invasion. Whereas war is defined structurally in the sense that Congress declares it, invasion is not, as we discussed. And as noted, there have been no cases addressing it, nor does the statute itself actually define it. So what is an invasion exactly? Is it a political question reserved to the courts? Or is there some definition that we can divine from other areas of the Constitution? It turns out there are other sources we can look at to help illuminate at least arguments about the meaning of the phrase. If we go to some founding error definitions from dictionaries, we can see that Madison defined an invasion as an operation of war, and other dictionaries from the time define invasion as relating to hostile foreign military sources or hostile encroachments. And we do have other constitutional provisions that use the word invasion, so we can look at these two areas of the Constitution and see what courts have said about another part of the Constitution at a very close time frame to when this statute was passed. Specifically, we have the Invasion Clause and the Guarantee Clause of the Constitution. The Invasion Clause says that no state can engage in war without Congress's consent unless that state is, quote, actually invaded, end quote. And the Guarantee Clause of the Constitution says that the federal government has to guarantee the Republican form of government to the states and, quote, protect against invasion, end quote. Let's take a look now at some case law that has discussed the meaning of the word invasion in the context, at least, of these provisions in the Constitution. You see here, our first case is from the Second Circuit, and it says that in order for a state to get the benefits of the Invasion Clause, it has to be exposed to armed hostility from another political entity, such as another state or foreign country intending to overthrow the state. That definition of invasion, if imported into the Alien and Enemies Act, would require actual armed hostility from the government in question coming into the United States, which is a narrower definition of invasion than its colloquially perhaps use. Now here is an important point that comes from these cases, though. The Ninth Circuit case noted that this seemed armed hostility definition of an invasion is not intended to be used to combat illegal migration. And there it said to California that whether there is an invasion or not is a political question that is reserved to the federal government. And so it was not for California to say it was being invaded if the executive said it was not. Let's now look at the arguments on each side of this issue of the invocation of the invasion prong to address mass illegal immigration. We will start by looking at the arguments that exist to support the executive's invocation of the invasion prong to achieve a certain end with respect to certain groups of people entering the country. Now at the outset, it can't be employed obviously to say that every person entering the country illegally is somehow a part of an invasion by a foreign government. Such a statement or claim probably would trigger the manifest error concept of the political question doctrine, and courts would reject it. But what if there is a more nuanced approach taken by the executive? For example, the executive concludes, based on the intelligence at its disposal, that the government of Venezuela has intentionally emptied its prisons of violent gang members and affirmatively sent them to America. Let's think of that fact pattern and now look at arguments. First, there is the fact that with respect to the war prong, as we saw in all the case law, there is very limited judicial intervention. In essence, the federal courts have said that the role of the courts is simply to look at the jurisdictional facts. Is there a war? Is there a citizen of a foreign country? If both facts are met, then there is nothing for the court to do. That analogy applied to the invasion prong would then support the idea that the president gets to declare an invasion by a foreign government. Perhaps even Congress issues a resolution to the same effect, and the courts can't really look under the hood, so to speak, as to whether it is really an invasion by a foreign government or whether it is simply mass migration by people illegally. Here then, the courts may find themselves in a position of deferring heavily to the executive's conclusion that this is an actual invasion by a foreign government, even if it is not an attempt to overthrow our country specifically. It is nonetheless some sort of predatory incursion or invasion, as found by the executive of a specific government sending a specific group of violent and/or armed people to the United States. Under the case law we have looked at, there is a fair argument that the courts do not get to second-guess very easily that determination. Second, the invasion language could be interpreted non-literally so that it is decoupled from the idea of war or from what was understood at the founding to be an invasion or a predatory incursion. And simply relate to the idea that there is a mass crossing of the border without consent or authority, which amounts in a sense to an invasion. And we can find, of course, some case law support for the application of the act outside the war context. Remember, several of the cases we looked at found the use of the act even after an actual war, as we conventionally understand it, was concluded. In those cases, even though there was no active fighting or hostility between the government of Germany and the United States after the summer of 1945, the Supreme Court still allowed the executive to conclude that the state of affairs was such that the act could be used to detain and imprison enemy aliens from Germany. That demonstrates that courts do not require there to be an actual war in effect for use of the act to imprison and remove people, and so that would support the idea that the invasion prong does not require an actual affirmative declaration of war by Venezuela against the United States, or vice versa, for the act to be employed more broadly. Finally, the political question doctrine, which counsels courts against the executive or legislative branch, would play heavily in the calculus here, especially given that doctrine has expressly been cited by many federal courts to justify a non-expansive judicial role in second-guessing. In other words, there are simply not judicially manageable standards to even assess and identify the existence of invasion beyond the jurisdictional inquiry of whether it has been concluded to exist by the executive or not. War and peace and foreign affairs squarely belong to the executive and legislative branches, and squarely are not part of Article 3, and so that would support the idea that the executive gets an expansive playing field here. And we have even seen some case law that could be used to support the political question doctrine here. When the state of California tried to tell the federal government that it needed to do more because it was being subjected to an invasion in violation of the Constitution's invasion clause, the federal courts told the state of California that it had no business asking the courts to look at that, because this was squarely something that belonged to the executive. Now, in that context, it was the executive not wanting to stop or do more about illegal migration, but the key holding is that it is not for the courts to address the executive's determination that there is no invasion. On the other foot, and the executive concludes there is an invasion, that doctrine and case law would support the idea again that it is not for the courts to second-guess that determination of the executive as to the existence of an invasion or predatory incursion perpetrated by a foreign government or drug cartel working hands in hands with a foreign government, for example, in our Venezuela hypothetical. So there we had the arguments for executive power. Now let's look at some arguments against it. First, the highly circumscribed judicial review in the war context was a function of the fact that both other branches of government were involved in making the determination of a war, and so that justified the courts not being involved in areas that they had no business being involved in. Determination could be seen differently by the courts because it is not something that is constitutionally vested in Congress to decide. And if it is simply something an executive gets to say because it wants to, courts may feel that they need greater judicial review as a check and balance on that use of the power. Even without heavy deference, the courts do have the right to figure out whether there is a war period that may be a simple question that delimits court review in the war context because of the congressional declaration. But if there is to be an invocation of an invasion, the courts, in order to have a full hearing under Section 23, look to figure out whether in fact what has happened is an invasion. Because there is no light switch test to go to in terms of an actual declaration by Congress, they may simply have to come up with a formulation of the meaning of the word invasion, put some meat on that bone, and then figure out whether this in fact is an invasion or not, notwithstanding what the executive has said. And if this is done, courts may well conclude that an invasion is essentially part of a war by a foreign government, or preparatory steps taken before an actual fighting more begins. And courts may conclude that even when armed gangs are sent to the United States by a foreign country, those acts are not an invasion, and are instead simply the act of a foreign country getting rid of its bad elements. If that definition of invasion is adopted by the Supreme Court ultimately, courts would be saying that this is not a statute that can be used to deal with what is fundamentally an immigration problem as opposed to an actual war problem. And that courts may feel well within their Section 23 rights of judicial review of the act when used. Third, courts may conclude that they need to assess the metes and bounds of, because otherwise the statute could be essentially weaponized by the executive to deal with illegal migration, without any check or balance by another branch of government. That is, the idea of the four dissenters in the Watkins case demands judicial review, and that conception of judicial review may be more consistent with 21st century courts. Now, the counter to that would be citing to the Supreme Court case that we looked at where they quoted that famous old case, which essentially said we have to trust the vote of the people, and if they elect bad results, they will fix it at the ballot box next time. Whether courts would stick to that political question type premise of deep deference in an invasion invocation of the act seems less likely. This is another way of saying that the war prong has checks and balances and systemic fencing principles that justify limited court review, and courts may well conclude that the invasion lacks such checks and balances from the other branches of government, and so it requires judicial review of a more robust kind. Finally, there is the question that has not been litigated under the Act, but which in our modern construction of equal protection and due process may well require courts to assess the constitutionality of the Act, and whether it engages in violations of due process or equal protection by referencing and concluding that natives, based on where they are born, are presumptively disloyal or dangerous. It also arguably raises due process questions about indefinite detentions, simply because someone is deemed based on their birth, ethnicity, or race to be disloyal potentially. Courts may today be more receptive to striking down this law because in our modern world, there are so many other laws and mechanisms that the executive has to deal with illegal migration, from our vast criminal codes to our vast intelligence laws focused on finding threats and dealing with them. Courts may conclude that the government is well armed to deal with problems, and so this law, which may have been necessary in 1798, is not viable in the modern world where we have different constructions of equal protection and due process. And based on that, courts may be more open to voiding the law. These, of course, are open questions without clear answers. Now let's turn to the second question. Do the people ensnared by the government get to have a federal court hearing before being removed to a prison in El Salvador? This is the huge issue that led to the airplane being ordered to return and the massive litigation that erupted in D.C., and then the Texas habeas litigation over removals. Let's look at the two cases to see the issues that have been tested thus far in the courts. In D.C., the locus of the first of our judicial executive wars, the district court received an action that sought to stop the deportation to Venezuela of a variety of people deemed members of the gang who were literally being removed. The judge at the oral hearing ordered the government to turn the plane around so that the people would be returned and the court could assess if they were properly categorized and whether the act could apply. The written order did not direct the plane to turn around. The government did not turn the plane around. The people were removed to an El Salvadoran prison under a deal El Salvador did with the America to take the people. This led to further litigation as the case went up to the D.C. Circuit and Supreme Court quickly. And here you see Eon R. slide the words of one of the D.C. Circuit judges during oral argument about this process of deeming people part of the removable category and then removing them without advance notice to enable a court hearing somewhere somehow to make sure they were removable. The D.C. Circuit then ruled 2-1 that the government had to have a proper process before removal, and that the D.C. court could handle it as a class action. This went to the Supreme Court in April 2025, and it ruled that a process was required, but that the cases needed to be brought in habeas, where the people were confined, not in the D.C. courts as class actions there. Neither court addressed, however, whether the executive had flouted a judicial order on the plane turnaround order, and so that issue may continue in the D.C. Circuit, even though it has lost jurisdiction to the Texas habeas courts. And so we will have to see if the courts essentially ducked the need to answer that question. Then in May 2025, the issue again made it to the Supreme Court, as habeas cases were filed to stop imminent removals on the basis that the removals were set to occur on a day's or several hours' notice, and that more time was needed. The Supreme Court agreed in a 7-2 decision. It ruled that in order to actually seek habeas relief, a detainee must have sufficient time and information to reasonably be able to contact counsel, file a petition, and pursue appropriate relief. It expressly did not address the legality of the removal or the use of the law, only holding that time was needed to have a hearing. It ruled as follows. In order to actually seek habeas relief, a detainee must have sufficient time and information to reasonably be able to contact counsel, file a petition, and pursue appropriate relief. We recognize the significance of the government's national security interests, as well as the necessity that such interests be pursued in a manner consistent with the Constitution. In light of the foregoing, lower courts should address AEA cases expeditiously. Now, there was a concurrence from Justice Kavanaugh that sheds more light on his thinking. You see his quote here with the emphasis he put on the words. That is clear message, it seems to me, at least as I read these tea leaves. It seems that he at least sees a robust court procedure to allow the courts to assess these questions deeply. He said, quote, "The injunction simply ensures that the judiciary can decide whether these Venezuelan detainees may be lawfully removed under the Alien Enemies Act before they are in fact removed." End quote. And his disagreement was also with letting this stew in lower courts any longer. He thus, as I read it, feels that the courts have enough on the law and executive order to make the call and end this litigation one way or another, without the need for further factual findings in any lower courts. So the Supreme Court did not take it all up on the merits the way one justice wanted, and so we have a situation of lower federal courts now taking the case one by one. And this brings us then to another case in Texas, where a district judge ruled on the merits of the Alien Enemy Act as used for the invasion proclamation, the very merits question Supreme Court Justice Kavanaugh wanted to address. This was the ruling of Judge Rodriguez, the first judge to address it. He found that the word invasion required a level of armed insurgents entering the U.S. at the direction of a foreign state, and applying that definition, he ruled that the president's proclamation did not make that case out factually. He said, quote, "Based on the plain, ordinary meaning of those terms in the late 1790s, the court concludes that the factual statements do not. The proclamation makes no reference to and in no manner suggests that a threat exists of an organized, armed group of individuals entering the United States at the direction of Venezuela to conquer the country or assume control over a portion of the nation." End quote. And as a definition he gave this, quote, "While the court finds that an invasion or predatory incursion must involve an organized armed force entering the United States to engage in conduct destructive of property and human life in a specific geographical area, the action need not be a precursor to actual war." End quote. Thus, the Alien Enemy Act was illegally used to remove people. This is one decision, and time will tell if it stands, given all the arguments we have seen on each side of this. But one interesting open question remains. What if the president modifies the executive order to make the invasion findings that the district court said was lacking? Remember, the definition was as follows. An invasion, or predatory incursion, must involve an organized, armed force entering the United States to engage in conduct destructive of property and human life in a specific geographical area. The action need not be a precursor to actual war. That would seem to be a political question, finding that meets the definition. And so the question of whether courts can then assess the validity of the basis for the facts would be the next set of litigation battles. Stay tuned. We have looked at both sides of the question of this act and how it could be employed in the modern world in a narrow circumstance. And we have seen it as a question to be litigated with arguments on each side. So now you know the law, its history, how cases have treated it, and you are armed to discuss the scope of judicial review, political question doctrine, and different conceptions of the meaning of an invasion in our law. Thus far, the district court in D.C. has ruled that some form of hearing is required. Courts in Texas have ruled the same thing, and the Supreme Court has made clear that it expects some sort of due process pre-removal. There are multiple cases in the lower courts now with lots of open questions. Some of the questions are procedural, such as whether the cases can be heard as a habeas class action, or whether each has to be its own individual habeas case. Other cases are addressing how much notice and opportunity to be heard has to be given. A day is not okay, but what if you are told you have a week? We saw some of the precedents here, and so that issue will get resolved too. We also will have to stay tuned to see what, if anything, comes off the judicial executive standoff over the order to return the airplanes. When the Supreme Court got the case thus far, it avoided that issue, as did the Second Circuit, and whether there is remaining jurisdiction to address it is unclear. It is certainly the thorny question that tests the fault lines between our two branches of government. Finally, the big questions will get to the Fifth Circuit and Supreme Court ultimately, and those involve the issue of whether the act can be triggered as President Trump did, or whether courts can declare the executive order invalid and not able to trigger the invasion prong to remove people. The big legal question revolves around the invasion declaration and scope of judicial review. As we saw, a district judge in Texas has declared the proclamation invalid, and we saw historical cases that may shed some light on this. It will no doubt get to the Supreme Court, and we will then finally get to answer this question. So stay tuned for future programs when we wrap all this up and see how the case law from the last 2 centuries is interpreted and applied today. Thanks for watching, and stay curious and watch our other Curious Lawyer programs.